Clearly, this was done not pursuant to any apprehension, but to defeat the orders that had been made by your learned colleagues. You can say there is nothing technical that can be able to enable any person using common sense and blessed with reasons by the Almighty God to interpret it any other way. That they were grabbed from the court registry to defeat the orders of the court setting them free on bond. In the case of Bennett versus the Horseferry Roads Magistrates Court, the issue was precisely that if you ought to have brought Bennett from South Africa an extradition order, and that order was not there, the court actually said, we cannot allow people to be tried in English courts. People who have actually been abducted. Actually, the truth of the matter in Bennett's case, the discharge was on the basis that he was abducted. In the context of this case, and the law has always meant the Constitution, the statute, promulgated rules and regulations, and judicial decisions of the court and judicial orders. There was a judicial order setting them free. Over the same facts, the prosecution, I was waiting for that. The prosecution, I concede, if these two accused persons had committed terrorism act in Mandera and Garissa, where this terrorism is actually perpetrated, it would have been a different ballgame. But it was the same offenses, the same set of facts. Now, the courts had said that there is no basis why your rights under Article 49 should be derogated, because that was the issue. Whether they defied the derogation of fundamental rights. Those magistrates said there were no grounds for derogating their rights and to ensure that they were further detained. Accordingly, any attempt to arraign them before you in disobedience of court orders and to defeat the proper administration of justice cannot be countenanced under the principle laid out in Horseferry versus Magistrate and in the Gedongori case, because it was the same case, abuse of power. Abuse of power cannot be countenanced, cannot be tolerated. Your Honor, the issue, you are told that there were no charges that were facing them. But you would read all the affidavit. And that is a specific argument that was made both in Kiambu and Roiro, where I was there myself. They said, we are holding these people on the basis of specified offenses. Mr. Maura Kabata had read you. Robbery with violence, arson, all these kind of things that are being cited today. And the issue for purposes of Article 49 of the Constitution is not the charge sheet, which is a legal document. It is, what are the offenses against this man and woman? The offenses were set out in an affidavit. So when today you are told we have a charge sheet specifying a terrorism, this is a fiction used to justify disobedience of the law and to justify abuse of power. Because if it is permitted to proceed as such, and that is a bigger question, the courts would effectively have lost control over the persons brought before it for purposes of any prosecution. Two small points. Your Honor, you are referred to certain provisions of the law. There is this issue that has repeatedly, you've been told, we are seeking judicial review of the decision to charge that has been made by the DPP. There is no doubt that the DPP can make decisions charge. There is equally no doubt, Your Honor, that the laws, the relevant laws says those persons will be charged before a magistrate. Laws in Kenya, as we understand, the first business of any court is to be satisfied as to its jurisdiction. That it does not share with the High Court. It is a personal decision that you must be satisfied that you have jurisdiction. Jurisdiction can be compromised or negated by the conduct of the state or of the prosecution. So that, Your Honor, as an example, you cannot have jurisdiction in a charge sheet saying that Degwajiro was killed yesterday. Degwajiro in court. There would be no valid charge. So that the charging, there are certain requirements that must be there. There must be some evidence Degwajiro is dead. There must be some basis. If he was killed in Europe, if he was killed by Gasheri in Europe, you must show that Gasheri was in Europe. But if the Gasheri was not in Europe, where Degwajiro was killed, it's clear you cannot say that you have a valid charge. Let us wait for the DPP and the police to give us evidence. There is no such thing. So that, Your Honor, it was the same thing that was before those courts in Roiro and Kiambu. That what is it that you have? The court said there is nothing. And the DPP was saying we need 21 days. When we talked about reason, the reason that must be used is, since you have been praying for 21 days yesterday, and it has just been denied, they are saying, decided now to charge. On what basis are you charging? You said it in an affidavit, you need 21 days. In the course of the bail being processed, you rearrest, or you abduct and call it a rearrest. You know, this is a mischief rule. The court must go to the mischief rule. The last 2 points on the Constitution is this. About your authority that we need to go to the High Court. First of all, I like the idea. The prosecution keeps mentioning the High Court. But what is good for the gander is good for the goose. If you see there are certain things the High Court can do, it must start with you. The police and the DPP disagreed with the magistrate. The law is clear. You could only change that by going to the High Court. So that the High Court cannot be held only against us. That you say, when you are supposed to go to the High Court, you abduct to avoid the High Court. When somebody else says, the magistrate protect me, you say, no, magistrate, you cannot protect. Go to the High Court. You can't work that way. Your Honor, that is not the law. But more importantly, it is my submission based on two clear provisions of the law before my learned senior Mr. Kalonzo proceeds with this. Clear provisions of law. Article 21 had been cited by my learned colleague Mr. Ondieki. 21